I have preferred to start the discussion with the case laws only, so that the fear which some students, I have seen those who have appeared also and those who are going to appear, those who are in preparation, they all have been slightly worried that do we need to now study some important judgments of court. I said only related to your political governance, not others. If in regard to a criminal case something is talked about, then you need not. But yes, if it is associated with fundamental right, if it is associated with your DPSP, if it is associated with any of the constitutional position, then 100% you need to know it. So, it means it is not that I need to know 100 or 200 cases, no, 20, 30 specific references, that is all in total related to certain things. In a few cases it will be CSRC recommendations which will be seen necessary, and in few cases it can be ARC observations, in few cases something from RBI, in few cases something from Niti Aayog, that makes a answer. Now, I will take you to the question. Let us see what the question is. The most significant achievement of modern law in India is the constitutionalization of environmental problems by the Supreme Court. Discuss this statement with the help of relevant case laws. 10 marks. Now, understand the background of the question, what the question is expecting from us, whether the question is of environment, I need to know about environment, or whether the question is about the concern expressed by the lawmakers, and here especially we are talking about Supreme Court in regard to the need for showing some respect to the environment. Okay? So, environmental problems, issues related to environment, we need to maintain the environment, we need to ensure that it is not deteriorating, rather we start working for its restoration. Okay? That is the core idea, we need to improve things. So, they are saying the most significant achievement of the modern law in India is the constitutionalization of environmental problems by the Supreme Court. Child, you must have heard of definitely Bhopal gas leak. Then again in 1986 gas leaked from the plant of Shri Ram. There also gas leak was there. Now, a PIL came in front of Supreme Court. Here Justice Bhagwati talked about the idea of absolute liability in place of strict liability. Okay? Absolute liability in place of strict liability. Strict liability will be coming up from British law of 1868, but now he talked of absolute liability. In what is the case? Let us understand. Then one can be this, another it will be polluters pay principle. Who shall pay for it? Polluters shall pay for it. Okay? A case related to Kamal Nath case, what is popularly termed, if you will search internet you will find it, related to Kamal Nath case, that a resort type of arrangement was created in Himachal Pradesh and on the forest land, and it was seen as a threat to the basin of river Vyas also. So, ultimately Supreme Court said that it is necessary that you actually provide for the principle of polluters pay. So, they imposed a penalty of rupees 10 lakhs on the resort owners, okay, and resort management, and asked them to compensate for the losses that have taken place to the environment. So, now how you write the answer? In first line, just highlight the significance of maintaining the environment. Why? Because if Supreme Court is talking about, let us say Parliament starts talking about, definitely these agencies will not take up those matters which are not very urgent. They will be taking up the matters which are genuinely urgent. So, concerns of environment where you will not talk of international agencies, international meets. So, a lot of things can be written about it. Rather, you will specifically come down to this idea that in this regard, Supreme Court also has been an important player to somewhere champion the cause of protection of environment. Okay? This will be your language, that significance of environment to somewhere ensure the sustainability, continuity of life of all forms. Almost all the quarters have been attempting conscious efforts to contribute to same, but in India it has been Supreme Court that has championed the cause, of environment protection, or protection of environment. And then you now will be required to come to straight away case laws. See, if I say who has been responsible for CNG buses in Delhi, control of vehicular emissions, then you will say courts of law, nothing else. It is simply courts of law who have been responsible for somewhere ensuring that government is also taking it into its consideration that law making is must. Okay? So, removal of all the buses from the fleet of DTC which were using diesel engines, this all credit somewhere will go or will be going to judiciary. So, I am not saying, it is not the idea to belittle the efforts which your ministers or your legislature have been making, but important is that in this particular answer we highlight the significant contribution that Supreme Court has provided. So, let us see constitutional provisions related to environment. Why Article 21 has been given? You will say straight away that the answer Article 21 has been given in regard to right to life. Okay? Stubble burning in Punjab, some parts of Haryana, mainly Punjab and even in Uttar Pradesh. Whether it is a threat to right to life, which will be seen expressed in terms of your right to fresh air, unpolluted air, right to breathe in unpolluted air, somewhere will be seen as an expression of right to life. So, when we are understanding that why Article 21 should be mentioned in it, it need to be mentioned very early where you will be talking about it. Then child, we are talking of constitutional provisions. 48A, 51A, I think you must be understanding why it becomes A separately, it is not Article 48 only. It has to be seen in terms of the amendments made or later insertions. So, both of these have come, if I see this article and this article, they have been inserted through 42nd CAA Constitutional Amendment Act. Okay? So, these two have come from 42nd Constitutional Amendment Act. You can even mention that concern towards the environment has been shown way back in 1970s by our own parliament, which has actually provided for one obligation for policy making on the state and another obligation in fundamental duties on the citizens. So, duty to protect the environment has been somewhere entrusted on both the government, that is the state, as well as on the citizens. So, if you would have mentioned in it, but it will be because remember it is just a 150 words, it is not 250 words. So, if the question is repeated in a 15 marker, then you can go in slight details. Otherwise, simply you will be talking this statement that Article 21 provides for right to life, right to breathe in fresh air, okay, and unpolluted environment. Then you will come that in regard to protect the environment through 42nd MCAA, Article 48A and Article 51A have created obligations through 48A on the state and 51A on the citizens, fundamental duties in bracket you can write, where they are expected to protect the environment. If I read the articles specifically, the state shall endeavor to protect and improve the environment, clearly written. So, this is, you will say, is it the main body? No, it is introduction we are talking of, but it is only to, as I was saying, that yes, I am respecting Supreme Court, but it is not so that legislature has been not at all concerned about the environment. So, you need to talk about it. And then through 51A, it shall be the duty of every citizen of India to protect and improve the natural environment. Now, what natural environment will include? Forest, lake, rivers and wildlife. So, polluting rivers by any industry, okay, it can be Ganga, it can be a river in Tamil Nadu where cases have been there, lakes and wildlife, this somewhere could have been the language of your answer. So, this is where you actually fix the initial part of your answering. Let us see, this is the situation as per the constitution. Then again, Parliament has the power to make any law for whole or any part of the country for implementing any treaty. This is Article 253, where it is clearly saying that irrespective of the subject falling in any list, Parliament can make a law if it has to go for implementing an international treaty or agreement. And then why it has been provided here in related to environment, you will straight away come to Stockholm Conference of 1972, where it was provided that Parliament has the power to legislate in all matters linked to the preservation of Natural Environment Act, Parliament's use of Article 2 Air Act and Environment Act. Fine, this is the act related to protection of environment we are talking about. You can also talk about the moving of subject from state list to concurrent list, but if you ask me, not desirable in it because it is 150 words only. I will now come to specific cases. Never forget to mention MC Mehta case, favorite of your UPSC examiners and also very popular. Then Kamal Nath case, this is basically in regard to which provides the doctrine of polluters pay. So, a lot of penalties you must have actually seen, even municipal bodies, state agencies, they say that on a builder or if any construction is going on, it is your duty to ensure that you are not harming the environment. The pollutants shall be kept in check, okay? Dust pollution, any type of pollution, you are actually responsible for it, and state agencies are seen imposing fines. Polluters pay principle. If a question by chance next year comes like this, that do you think that this type of fines and other things, then this is the case, okay? Here it is also written. Now, now we are talking of oleum gas leak case 1986, MC Mehta. So, why this case becomes important? Because just 2 years earlier, from the plant of Union Carbide in Bhopal, a major disaster has taken place, in which around 2200 people lost their lives and many had to face the impact of that accident for years to come. So, in this case, Supreme Court created the idea of absolute liability principle. Companies engaged in inherently hazardous activities has absolutely no excuse when an accident occurs. So, whatever arrangements you need to bring, you should bring them in place early. You cannot come later saying that it happened by chance, that was not there. No, there are no excuses. In absolute liability principle, there are no excuses. Whatever could have been the reason, your liability to compensate will remain. Okay. So, now it is as it is 150 words. So, straight away you will just keep coming. Let me tell you about Kamal Nath case that I talked about. It was a case about having a resort, okay, in the forest area where some forest land was taken, and it was also seen endangering the basin of river Beas. So, in Kamal Nath case, you will be talking of Supreme Court established polluters pay principle and public trust doctrine. Then in oleum gas leak case, MC Mehta, okay, case, Supreme Court created the absolute liability principle in place of strict liability. In place of strict liability, the idea now was absolute liability. Okay. So, it is the responsibility of companies which are involved inherently in these type of activities that they need to say. Can you actually recall one case study from ethics also, which almost in every year has been there, where a particular company has been involved in actually polluting the river water or polluting the lake, polluting the environment around, and you are one of the employees of that company, you come to know about it. Do not forget to mention this case. That is a 20 marker. If you will mention certain cases with evidences like this, then you will be able, in the case it is expected that how do you convince the management. So, you will be talking about these things, and then you will be having weightage, because you will be proving to your management that sir, what you are doing is illegal, and it is an established principle that absolute liability is on you, means you are expected to take all the measures which can be there to prevent any sort of accident. Okay. More cases. Kendra versus State of UP, also known as Dehradun quarry case, where mining of lime was going on. Okay. So, in this case also, Supreme Court of India held that pollution caused by quarries adversely affect the health and safety of people, and hence the same should be stopped as being violative of Article 21. So, this is also an important case where some famous contractors were continuously, even after directions given to them by committees, initially the case has gone to courts of law, and courts of law appointed a committee to monitor. The monitoring committee asked those people that you take certain precautions, and fine, with certain precautions you can continue with the query work. But later on, coordination committee said that sir, they were not at all willing to observe any of the condition which has been talked about by us, and they are a serious threat to the environment. And finally, Supreme Court stopped all quarrying in that Dehradun hills, stating that it is violation of Article 21, and everything was done away with, over. And then we take another case, Subhash Kumar versus State of Bihar, right to get pollution free water and air as a fundamental right under Article 21. Okay. So, same thing, what should be done with those who are polluting Ganga? So, it is not about a sacred river, it is about that it is a source of water, and it need to be pollution free. It need to be pollution free. So, right from that sense, and then you can take up the case if you want. Already 4 cases, it is more than sufficient. Okay, more than sufficient. These are, when you are talking of 4 cases in a 150 words answer, that is more than sufficient, and then you can just push it. So, friends, when you are talking about that what are the case laws, relevant case laws you need to talk about, do not worry. Some names, of course, it is expected that you know, like this is a very popular case, very, very popular one. Okay. Then I check, this is a very popular case, this is also a very popular case. So, these 3 cases I think almost every good book of polity should be having. Otherwise, if the book is not having any such thing, then definitely some problems are there. Okay. So, this is how the second paper, in its opening question, expected from you some sort of surety that you understand that issues, they highlighted environmental issues, some other issue could have been there. They have, it is not so that our governance is poor and without principles. We are very progressive and we have provided for certain principles.